Welcome to the Extra Mile podcast for bar exam takers. There are no traffic jams along the Extra Mile when you're studying for your bar exam. And now, your host, Jackson Mummy, owner of the Celebration Bar Review.
Hey everybody, welcome to episode 264 of the Extra Mile podcast for bar exam takers. This is your host, Jackson Mummy, and I'm glad to have you with us today. This was not an episode we intended to record. We were actually going to take a week off since this is the week of the actual July 2019 bar exams. But as you probably have heard, there was a major disaster in the California administration of the exams that occurred late on Thursday, Friday, and Saturday of the week preceding the exam. And I felt it was important to get back online in the podcast, talk about it, give you the information that we have. And that's what we're going to do today. Now, if you're not a California bar taker, this obviously didn't affect you directly, but there are questions that are raised by the occurrence in California. And if you're not familiar with what happened, the brief story is that the examiners released the testable topics for the exam to a group of 16 law school deans 5 days before the test. So, could that happen somewhere else? Well, apparently it could, and I think it's worth being aware of what happened in California, what they're doing, and some problems that I think it raises. So I hope you'll stick around. Obviously, if you're a California bar taker, you're well aware of this. And if you're now planning to sit for the February 2020 or July 2020 exams in California, I think this is vital information for you as well. So we're going to jump into that in just a minute. I do want to let you know, as always, that you can watch or listen to our podcasts. If you prefer to watch, you can go to celebrationbarreview.com/264. If you prefer to listen, you can listen on Apple, iTunes, on iHeartRadio, radio.com, Spotify, almost any place that podcasts are syndicated. And finally, I just want to remind you that our podcast is brought to you by our free webinar. It's called Do Something Different. I wish the examiners had done that. Make the next bar exam your last bar exam. It's a free webinar in which we take you through the 4 steps that successful students follow to pass their exams. We've got all kinds of case studies, hearing from students in their own words, and lots of great information for you. You can watch and participate in this webinar at your convenience, the time and date that's most convenient for you. But you do need to register, and you can do that by going to the show notes on any of the podcast pages or by going to celebrationbarreview.com/webinar. So be sure to check that out and then join us on the webinar. I think it's a great resource and something I hope that you'll participate in and find valuable, as thousands of other people have already. All right, I don't want to keep you waiting any longer. Let's jump into our discussion today of questions that we've got for the California bar exam. Truthfully, it's hard to even know where to start with what's occurred, but let me give you the basics of the events as we now know them. On Thursday, July 25th, the California State Bar says that they inadvertently emailed a memo, and it was sent to 16 law school deans, and I'll tell you what schools they were in just a moment. And it was not intended, they said, to be sent until after the bar exam. The examiners say that this memo was a routine invitation to observe a calibration session of the grading process to be held in late August, and it included the subject matter of the essay questions, 5 of them, and the performance test. Now, according to the official release from the examiners, once the State Bar had determined that their control over the information had been lost, remember this happened on Thursday, they decided to release the information of the testable subjects and the performance test in order to create, quote, a level playing field for all. Now, the bar examiners claim, at least as I'm recording today, that they had no indication that the information had in fact been disseminated. I have very strong doubts about that. I'll tell you more in a moment. But they decided to act proactively to address the worst case scenario. However, they decided to wait until Saturday night, the 27th of July, so 2 full days later, at 9:30 p.m. Pacific time. So really almost 3 days later, the State Bar notified all of the applicants and all of the law school deans in California by email with a message that said, here are the 5 testable topics and what the performance test format is going to be. A similar notification was then sent to all national law school deans on Sunday, July 28th. Now, this email that went out on the 27th, actually, many of us thought it was a hoax when it came out. It was very poorly described and written, and it looked like somebody might have hacked into the database and sent this out. So there was a great deal of uncertainty until probably midday Sunday, the 28th, when the examiners actually came out on their website and said, no, it's not a hoax, it's actually the real memo. It came from someone named Donna Hershkowitz, and frankly, I've never heard that person's name before. So it was not something that people would say, oh, sure, it's from Jason Lee, I understand, I know what's going on. That meant that potentially some people had that information for 2-3 days, maybe more, before anyone else did. At that point, the examiners then tried to correct the problem. They issued a series of releases. They even did a video, and we'll link to all of that in our show notes so that you can see everything that the examiners sent out. The net effect of all of it, however, was to create a massive amount of uncertainty and to create the appearance of a lack of transparency and integrity and to demonstrate a lack of fairness. And it's really stunning to me how obliquely and I think rather casually the bar examiners have taken this. They continue to say, well, we apologize and we hope it didn't create too much inconvenience for you. You got to be kidding me. A few days before the bar exam to say we've leaked the topics to some people, but not you, but now we're going to tell you. And hey, sorry for the mistake is absolutely mind-boggling. I can't even say the words, it's so mind-boggling. Now, as we began to find out what was going on here at Celebration Bar Review, we immediately went to our students with the information, and we notified them that if any student wished to defer, to not sit for the July exam, they could do so without any fee to be charged by us. We then pressed the California Bar to take a similar good faith effort and to refund the test fees for any student that decided to defer. Well, the examiners went ahead and did this. However, they didn't announce it until the day before the test, and they made the offer good only until Tuesday morning, July 30th at 8:30 a.m. So hopefully, if you were affected, you jumped in and made your request and got your money back if you decided to defer. All right. As I'm recording today, the test is going on, but I have some questions for the examiners. I've tweeted about several of them. I've written about them on our webpage and on our Facebook pages, but I thought that I would use this forum to talk about some things that I'm concerned about in this situation. I started with 10 questions for the examiners. I think maybe I'm down to 7. I don't know, maybe it's more. I don't know. We'll count them up at the end and we'll put it in the title. But here are some questions that I've got for the California bar examiners, things that I think they need to answer. The first question that I had, they finally answered today on the 30th, and that was, who received early notice? You remember that the examiner said they sent the notice to 16 law schools. Now, I think for perspective, you have to understand there are 62 law schools in the state of California. Seems very odd that they would send it to only 16, and they didn't disclose what those 16 schools were until late in the day on the 29th of July. I don't know why they chose to withhold that information, but here are the schools, and I'm going to list them, that they actually invited and sent the email to. And what I want to do as I go through each one is to let you know its status generally in terms of accreditation. So the first one was Abraham Lincoln University School of Law, state accredited. Cal Northern School of Law, state accredited. Glendale University College of Law, I'm not even sure it's state accredited. Humphreys University Law School, not accredited. Lincoln Law of San Jose, state accredited maybe. Northwestern California University School of Law, not to be confused with Northwestern University, not accredited. Oak Brook College of Law, state accredited. People's College of Law, maybe state accredited. San Francisco International University College of Law, state accredited. San Francisco Law School, Alliant University, state accredited. So far, we don't have a single ABA school that I'm aware of. Taft Law School, state accredited. Trinity Law School, state accredited. UC Hastings College of the Law, finally an ABA school. University of Laverne College of Law, state accredited. University of West Los Angeles School of Law, state accredited. Western State College of Law, state accredited. Those are the 16 schools. What in the hell are they doing? The examiners say, and I find this very, very, I'm not persuaded. They say there's insufficient space to accommodate all those who might be interested in attending our grading calibration. And so it's a select cross-section of California law schools invited on a rotating basis. Now, I've been teaching the Cal Bar for 30 years. I have never heard about this. They have never talked to any of us in the bar review industry that I'm aware of about this. They haven't invited us. They haven't given us any information about this at all. And the schools that they've picked are almost all schools that are in deep trouble with their bar pass rates. That strikes me as a very odd group of schools. I would have expected them to say something to USC or UCLA or Stanford, but no, the only ABA school that's on here is Hastings. They also indicate that they are doing this every year and that they do it on a rotating basis. I want to know how long they've been doing it. I want to know what schools were invited what years. I want to know what the pass rates are from those schools. And I think, frankly, we should watch the pass rates from these 16 schools to see if there's any change or difference from where we started. Now, part of the reason that I am deeply concerned when I see this list of schools is that I am also aware that many of the deans of these law schools are either on the faculty or the staff or the payroll of major bar review companies. Now, I'm just going to say this straight up. I don't really think it's plausible that a law school dean of a failing, difficult, bar-challenged law school, given this treasure trove of information 5 days before the exam, took the email, folded it up, and put it in their desk and did not tell a soul. Do you believe that? If you do, great. But I think it is more likely than not that, in fact, they told people. Now, I don't think any of these law school deans were stupid enough to send out an email. If they did, that will be really interesting. But I suspect that they walked down the hall, they walked into the library, they walked into the place where the bar was being prepared. They called the big box bar reviews that they were working with, and they said, guess what I just heard? And frankly, that was all it takes. Now we have an unfair playing field. Now we have people who had a running start, as it turned out, of 3 days to eliminate subjects from their study, to know specifically what subjects to study and how to study them. And I find that absolutely unconscionable. And frankly, I think the examiners try to make light of it as though it's not really a big deal, but it's a huge deal. And so I am deeply concerned. So one of the things that I want to know is, what are they doing to prove that none of this information was distributed? In other words, I would like to see a sworn affidavit from every law school dean saying, I did not distribute this information to one other single person. That'd be interesting, wouldn't it? I don't think we're going to get that. And so as a result, I think the presumption is that, in fact, some, many, perhaps all of these deans decided to tell someone in their staff, someone around them, someone in their school, some applicant somewhere, what these subjects were. Now, in terms of another question that I had was, why did you have to put the topics into the email if you were talking about a post-exam grading process? And again, the examiners have a pretty glib answer. They say, well, often other law school staff attend depending on the subject matter, which is why this information is included. Wait a minute, you said you didn't have enough space just a minute ago for everyone to attend, but now you're saying you could bring more people depending on the subject that we were going to test. You guys got to get your story straight here. What is it that you're really trying to tell us? You really mean to say that the California bar examiners, with all of their resources, couldn't find a room large enough to bring in all of the law schools and all of the bar reviews, or a representative of each, to see the calibration of the grading process? It really doesn't make sense to me, and it's really a thin excuse, I think, in that structure. All right, so that's one of the questions that I think we have to explore deeper. Second question is, in my mind, the email was sent out on the 27th. It took until Saturday the 29th at 9:30 p.m. Pacific to take any action at all. And then the action that was taken was so obscure as to look like it was a hoax. Why did it take so long to take action? The examiners say it was a human error, not a systems error. So somebody knew what had happened immediately. So for at least 2 days and into maybe 3 days, no action was taken. On a Saturday night, when applicants are traveling to get to bar exam sites, when there's probably the least amount of traffic and activity and interest on the website, an email is sent out with no covering information, no verification, nothing to identify it as being plausible or real, and then no follow-up for more than 12 hours after that. Frankly, that smacks of letting the problem fester and not thinking it was a big deal until it became a public relations problem for the examiners. That period of time is significant. At the last week before the exam, every hour counts, and to give some students and some applicants an advantage, I think is remarkably callous and remarkably arrogant of the examiners to think that they could do that without having to explain why or how. And there has been no explanation of what happened between the time of the disclosure of the error, and we don't even know who disclosed the error. Was it someone in the Cal bar exam? Was it a dean? Was it somebody at one of the schools? We have no idea how it was disclosed, and nothing has been put out to explain that. All right. The third question I've got, I've already mentioned a little bit, and that is, what assurance is there that the information was not distributed to any other applicants? Again, the bar examiners have said nothing. They have made the assertion that it won't affect anything, and we don't think that it was given to anyone else. And we talked to a psychometrician who was involved in evaluating and scoring the exam, and said, that psychometrician said, release the topics to everybody, that'll level the playing field. Oh, bullshit. I'm sorry, that's just remarkably stupid. That is not going to level any playing field, particularly depending on the amount of time that people had it. And to tell us that they are certain that nothing was disclosed, but they're taking all of these remedial radical actions, really are internally contradictory statements. You either know that the material was released or it wasn't released. And I think that this is trying to have it both ways, and I think it is remarkable. I'm looking for, as I said, sworn affidavits from these deans and a thorough and complete investigation by an outside independent source, not affiliated with the California bar exam, not affiliated with the California bar, to examine what happened and when it happened, and to talk to those 16 law school deans and see exactly what they did with the information. All right. Next question I have is, why were only some deans invited to the grading process? And the examiners have said that it's rotating, but this is not a rotated kind of list. This is a very targeted list of some of the worst performing law schools in California. So I think to suggest that it was just random selection doesn't really make sense to me. It is not a random selection. If you ask me to find 10 of the worst performing schools on the bar exam, these schools, other than Hastings, would be on my list. Almost without doubt. And so to me, again, it's disingenuous to suggest that it was random. I want to know why those schools got it, and when's the last time those schools were invited, and how often are they invited, and has every school in the 62 been invited, and how many years does it take to get through all 62 schools? Is it always 16 schools? Sometimes is it more? Is it less? And how many of these law school deans work for bar exam companies? I think the answer would surprise you. Most of these lesser tiered law schools, the staff, the faculty, and the deans are very often on the payroll of the big bar review companies. And so in effect, what they're doing is giving some distinct advantage to certain companies. And frankly, while I'm not worried about getting my share of California bar review business, I've got plenty, I think it's deeply unfair to the students that sign up for one bar review course versus another. And I think it's putting the thumb on the scales, and it's something that I think just absolutely should not be tolerated. All right, the next question. Why were the topic areas necessary for the invitation? Well, again, the examiners say, well, we needed that. We needed to tell you so you could bring your staff in to look at it. Really? That's really necessary? I mean, a law school dean couldn't understand how to answer a contracts question or a con law question? I don't think so. A law school dean wouldn't know how to look at the calibration of a performance test that's an objective memo? I don't think so. You know, again, there's just too much about this that really smacks of making up an excuse afterwards and trying to fit the story in to fit. It just doesn't hold water for me at all. Next question I've got. What are the historical pass rates for the schools that are affected? Well, I can tell you that, as I said, those schools that we talked about are among the worst performing schools. So were the examiners trying to give them a break? There's been enormous pressure on the bar examiners to try and increase performance. Was this a way to help out those schools? And even if it was done in good faith and nothing was released ahead of time, what was the point of inviting just those schools afterwards? Is it to help that particular group of students improve? And frankly, if I've gone to another low-performing law school, I'm going to be pretty unhappy to find that Cal Northern and the People's College of Law and Taft and University of West Los Angeles, their deans got to go, but my dean didn't. And it strikes me again as being unfair and something that should not have been done. My next question is whether or not this is a fair procedure. I think that it was not fair to continue on with the exam and to simply say, we'll give you a refund if you don't want to show up. We encouraged our students to pull away from the exam because when you understand that there are 9,000 people taking the test, roughly, and that's what the examiners are saying, there are about 9,000 people approved for the exam in July. And we know that about 1,000 to 1,500 will pass. Well, if you've already taken a group of people and given them an unfair advantage, and we don't know if that material went out to students at one school, did they share it with other people that they knew or people in their bar review courses or in online forums or other places? There is literally no way to tell. And so the level playing field is no longer there. And so the students that didn't get this information, though they got it a few days before the exam, frankly, what are you going to do Sunday before the bar exam on Tuesday that's going to be substantial when everybody else may have had this information for 3 days previously? So the examiners asked some questions themselves. Did they consider changing the topics for the exam? And they say, yes, but we didn't have any backup questions. You know, I think that's probably true. Most examiners have 1 or 2 backup questions. They rarely have a full test. But I know that in some states, they do have a complete backup test in case there's some violation of the integrity of the exam. Florida comes to mind, for example, another big state. And frankly, it seems to me that there would have been some body of questions, and it seems unlikely, given the size and scope of the California examiners, that they couldn't come up with 5 essay questions. There've got to be, over the years, a fair number of questions that they have not used that they could have used here, and they could have changed the topics. They chose not to. What about postponing the exam? Well, the examiner said there wasn't enough time to edit, pre-test, re-edit, print, and package an entire set of new test questions. Yeah, that's true. It probably wasn't. So why didn't you postpone the exam? You could have certainly postponed day 1 of the test. Day 2 is the multi-state, and you could have held the multi-state on Wednesday and then held the rest of the exam on Friday or Saturday or Sunday following that. It doesn't take that long to produce all of those pieces. And while the examiners don't have the ability to change the date of the multi-state bar exam, they certainly have the ability to change the date of their exam. It used to be a Tuesday, Wednesday, Thursday test. Now it's a Tuesday test. So frankly, I think the examiners should have done that, and they should have been willing to pay for changes in travel or lodging that might have been required. So what they said is, ultimately, we determined the impacts of postponing would be too great on examinees who've planned and studied for this exam date. But we're okay with the fact that it may not be a fair test. I mean, that's my addition to this. So there you go. That was their reasoning. Then they answer the question, how will this affect the scoring of the exam? And they say, won't affect it at all. We're going to use the same scoring protocol and procedures in the past. We're going to assess, we're going to make every effort to assess what the impact will be on student performance, and we'll carefully monitor this aspect to preserve the integrity of the bar exam. What does that even begin to mean? It's just doublespeak. I'm sorry. If any of you really know what that means, feel free to note that in the comments and tell me. I don't think it means a bit. I don't think they've identified any way that they plan to monitor the impact on student performance. They're still going to have the same number of people pass, and I don't think there'll be a change at all. And I think they'll brush it off as it was no big deal. And then finally, what are you doing to make sure this doesn't happen in the future? And their answer is, well, we apologized, and we're committed to ensuring the integrity of the exam. Well, I bet you are. And they say, we did everything that was sufficient to ensure the integrity of the exam, but we decided to launch an independent review of the circumstances to identify any measures we may need to take to prevent such occurrences in the future. You know, this is really corporate damage control. It's PR fluff, and it's designed, I think, to make people think they're doing something, when in point of fact, I don't think they're doing anything at all. Now, I know that you can tell I'm angry about this. I am deeply angry. I am frustrated for my students. I'm frustrated for anyone that wasn't included in that pre-release of information. This is the most appalling lack of integrity that I have seen from bar examiners in more than 30 years of teaching the exam all around the country. There is no excuse for what happened here in California. If it was human error, that individual should be dismissed, and there should be a deep and wide inquiry, and it should go to the top levels of the California bar examiners. It should also include an inquiry into each of these 16 law schools, and it should be in depth as to what happened in those schools and what happened to that information. I honestly believe that anyone sitting for the July 2019 exam now has the imprint of a potentially unfair test result, and that's unfortunate. I encourage you, if you sat for the exam in July 2019, regardless of your results, if you did not pass, to step back in and take the exam in February 2020. If you can take it in a jurisdiction other than California, I would encourage you to do that. But if you have to sit in California, take the exam in California, talk to us, we'll be glad to help get you prepared. If you took the exam in July 2019 and you pass, I think that is remarkable and wonderful. I hope that it is in no way tainted by the results that came out. Your accomplishment is your accomplishment, and you should be very, very proud of it. But I really want to stop here by saying that the integrity of the bar exam rests wholly on the bar examiners treating every applicant fairly and in a uniform way. What we have here is the furthest thing from integrity and fairness and equality. And to me, that is absolutely unthinkable. And there were many other ways that the examiners could have dealt with this than what they did. And I think they're going to have to be an accounting and a reckoning for what they've done. Well, those are my thoughts. If you have different feelings and opinions, I encourage you to chat about them. Put them on the comments pages here. Email us. My email is jackson@celebrationbarreview.com. I'd love to hear from you. If you were impacted by this, I'd like to hear from you as well. We will keep you informed on this story as it develops, as we learn more information. It has literally been dribbling out since Saturday night, and it's a little piece every day, it seems like, and I'm sure that there will be more to come. I want to wish everyone that was in the exams this week the very best, regardless of where you went to school, regardless of whether you heard about these topics in advance or not. I hope that everyone conducts themselves with the integrity that we would expect a member of the bar to use in all circumstances. And we'll be back to you next week to keep you informed and let you know what the fallout is from this remarkable set of experiences and events here in California. Well, that's our episode for this week. Obviously, it's a fast-moving, fast-changing situation in California. As I said, we'll keep you up to date on anything that we learn. Be sure to check out our Facebook page, Celebration Bar Review, and our website, celebrationbarreview.com, for any updates and information as we learn it. And come back here next week for our podcast, and we'll let you know what else we find out. In the meantime, if you're taking the exam in 2020, I want to just remind you to check out our free webinar. It's called Do Something Different, Make the Next Bar Exam your last bar exam. And you can register here on the show notes or by going to celebrationbarreview.com/webinar. Okay, everybody, hope you have a great week. If you were in test this week, hope it went well for you. And we'll be back to talk to you next week along the Extra Mile.
Thanks for listening to the Extra Mile podcast for bar exam takers at www.celebrationbarreview.com.